ladies and gentlemen, you can get XRP and many, many other tokens that that are on this platform at Uphold. I love Uphold. I use it all the time, more often than Mrs. Backup would like me to. But I tell you, if you're not aware, even if you're a customer of Uphold, click the link underneath the video, check them out, earn up to 25% APY while staking. How about that? Take advantage of their highest ever APYs, ladies and gentlemen. Check out that link. Just in, U.S. Treasury fines Bittrex $53 million for violating federal sanctions. As we get more, we'll report on it, but that's what we've got thus far. BNY Mellon says we're reimagining financial markets through blockchain and digital assets. Say it isn't so. Select U.S. institutional clients can now view traditional digital assets on one platform. Secure and resilient digital asset custody, a milestone in our innovation journey. This is where the article here is. It breaks it down, but you got what the gist of it is. This is a nice reminder from Cowboy Crypto. Back in 2016, Ripple did proof of concepts with BNY Mellon, and you can see it right here. Is it tied into where BNY Mellon is going today? It's speculation. I believe it could be, but we'll keep paying attention to it to find out. Shout out to XRPville. This is another great clip from SIBOS. Listen to what they're working on there at Swift.
We're achieving it through Swift's new transaction manager that is acting as a bridge. And exciting to see as well that an increasing number of major central banks and commercial banks are joining this sandbox. And we have similar experiments as well going on the security space with leading edge innovation on tokenization. As digital assets mature, they can also be seamlessly exchanged across borders.
And there you have that. And one has to wonder how they're going to effectively do that, knowing that Swift is not an innovator themselves, and Swift GPI is actually a messaging platform that's better than what they've been doing, but not an instant settlement platform, but an instant payment messaging platform. So this gets interesting. We know R3 has a tie. We know that there's a tie between R3 and digital assets like XRP. Will they be gravitating to a moment where everybody's going to be working together? It does feel that way. It really, really does feel like we're working towards a moment like that. This is DC Fintech Week with Brad Garlinghouse. And as always, laying down the fire here. I'm going to play a couple clips. Shout out to DAI for these. Check it out.
All right. Well, we have a limited amount of time here, so I'll go ahead and just get us started. I think we'll start with an update on where Ripple is with its lawsuit with the SEC, that little known lawsuit. So for anyone who hasn't been following the case, the SEC sued Ripple in 2020 for allegedly raising money by selling its XRP token, which the agency said should have been registered as a security. You recently won access to some documents you were seeking. Both sides have also asked for summary judgment. So maybe give us kind of an update.
State of the state.
The state of the state. Where do things stand, and what's the significance of where we're at?
Well, it's great to be here. It has certainly been a busy couple of years. As you said, the SEC first filed a lawsuit against Ripple and actually myself and Chris Larson in December of 2020. So it's been almost 2 years. And, look, I think at the beginning of this, we actually made the public statement that, this isn't just about Ripple. This is really about the whole industry. And I think at the time, in December 2020, people were like, no, it's not about the whole industry. Today, I think everyone acknowledges how important this is for the U.S. and the U.S. leadership around crypto. This is obviously, I think everyone would agree now, a pretty bellwether case. Where the case stands now is both sides, the SEC and Ripple, have filed motions for summary judgment, which basically means, hey, we don't think we need a trial. This isn't a question about the facts, it's a question about the law. We think the law is very clear, and the judge, those will be fully briefed in front of the judge by mid-November, and then the judge will take as much time as the judge wants to take to make that decision. One thing you commented on that I think is worth spending 1 second on, the judge, so there's some notes associated with for the crypto industry, a very well-known speech that Bill Hinman gave in June of 2018. And in this speech, he said that ETH had, I'm paraphrasing, but ETH perhaps had been a security, but it transitioned to not be a security because of its decentralization. And, that's not actually what the law says. What the law says, there's no mention in the Howey test about decentralization, but that speech was really, really important. And the judge now, over the last 18 months, has ordered the SEC to turn over the notes associated with that speech 6 times. So the recent discovery ruling that went our way is just the 6th time. And the only reason I mention that is because the SEC obviously celebrates disclosure. It celebrates transparency. Like, why can't we do the work as the SEC and as a federal government to actually define and provide clear rules of the road? And if we had those, I think everyone would actually, the industry in the U.S. could thrive, much more easily than what we're dealing with now.
So, in kind of the order that you were talking about, are you expecting that to help, even in the case of summary judgment, or is this more of something that you're looking to help in the slim chance that the judge denies those motions and this goes to trial?
Well, I think the question we're asking is, what are they trying to hide? What is it in these notes that they have been ordered 6 different times to turn them over to us and we still don't have them? Exactly. Each time they've, filed appeals or, new derivations of attorney-client privilege. And, so for me, as much as anything, it's what is in these notes that they are so committed to not sharing with the world? And look, I think most people who look at this situation, by the way, I have no idea. I can't wait. I hope we get to see them. We'll find out. I hope. But, if you step back and just think about this from the big picture, at the time, XRP, and people forget this, but at the beginning of 2018, before that speech, XRP was the 2nd most valuable digital asset after Bitcoin. Mm-hmm. And then the SEC kind of anointed ETH. And ETH obviously has benefited from that. And then not too much longer, another year and a half later, the SEC filed a lawsuit against Ripple asserting that XRP is a security. And the nuances and the distinctions between, is something adequately decentralized to make it not a security, which again isn't what the law says. And again, I'll digress and maybe pontificate for 1 second. I think we all have to remember the SEC only has the power that Congress gives it by statute. Right? They don't just get to go and take power. Congress gives them that power. And in this case, it's the 1933 Securities Act that says, here you have to have an investment contract. And then eventually there was something called the Howey test, which we can talk about if it's, in the weeds, but interesting maybe.
All right.
It's very interesting here how Brad references, I hope we get to see those emails, right? It's very interesting that Brad Garlinghouse highlights what we've talked about here many, many times, that Ripple was in the number 2 spot, not Ethereum. And then a year and a half later, they get a stick in the spokes from the SEC. And it's awful damning that William Hinman has quite the portfolio because of his ties to the EEA and the law firm representing them. It's just despicable. But I tell you, all straight fire from Brad. Listen to this clip here about the future of crypto and blockchain.
Well, I guess speaking of the CFTC, I know that they recently had an enforcement action that Chair Benham spoke to, the OkiDAO action that also held governance token holders liable as well for the violations. I'm curious, I know some in the industry have been pretty upset about that action, having felt like the CFTC has been kind of an ally for them. What are your thoughts?
Well, I don't want to confuse being an ally with going after fraud. And I don't know the specifics of this particular case. I haven't followed it closely. I think there's no question there have been bad actors doing things they shouldn't do, and whether it's the CFTC or other parts, the Department of Justice going after scams and frauds, I think we all should support that and encourage that. What I heard, Chair, I was in the back when Chair Benham was speaking, and what I heard him say is, roughly, if DAOs think they can operate outside of regulatory frameworks, they're going to be sadly mistaken. Mm-hmm. On one hand, that was a powerful, important statement. On the other hand, I hope that's not a surprise.
Think about that for a second. We have talked about that since Wyoming created the legislation for filing to where you have to register as a LLC for decentralized autonomous organizations out of Wyoming. Because I said it then and I say it again now, it is to bring accountability to that platform. These developers who think I'm just creating something and throwing it out there that's decentralized and the world can just use it. Okay, I got you. And what you're creating is another version of the dark web that can move value that will soon become untrusted, because the truth is that governments around the world are not going to release the control, relevancy, and power that they've been able to attain so we can have some fancy, falutin, decentralized network somewhere. Matter of fact, the more decentralized they claim this space is getting, the more centralized I see it to be. Whether it is on the back side of the curtain where JP Morgan tries to take over an Ethereum like they've done, or whether it's on the front side of the curtain where we're watching a USD coin get on all of the major protocols that appear to be the ones that will be relevant going into the future. Not financial advice. And if they're successful, that means they control the on and off ramps and have all the majority of the liquidity in this crypto space. Isn't it? Tell me that's decentralized. It's like .com back in the day, the .com era bubble. Decentralization is a key word. Blockchain is a key word, right? It's a buzzword, just like .com was. That's what I'm seeing developed here, because what I really see taking place is the control being set up through either regulation or through the liquidity control of something like USD coin being set as the on and off ramp for all the relevant projects and protocols. Keep listening.
Well, and speaking to the enforcement side of things, I think what constantly comes up from the industry side is this idea of, regulation by enforcement. But I want to note too, this, the president put out a release on all of the reports we've seen out of the March executive order, which called for a coordinated approach to digital assets. And in that release, it did kind of sanction sort of the SEC and CFTC. What it said was it wanted them to aggressively pursue investigations and enforcement actions in this space. I mean, what do you make of that?
Well, I think the one interesting thing, my recollection of the executive order was the SEC was never named individually. It was the SEC and CFTC. And so right now the SEC is operating as if they are in charge. And they're gonna protect us from, I'm not sure what, Kim Kardashian. I do think, I go back to the executive order, I think is well-intentioned and brings attention to the need for clarity. I think all of us would benefit by continuing to push in whatever way we have available, whether that's through the court process, as Ripple is doing, whether that's through the legislative effort, the Digital Commodity Exchange Act in the House Ag Committee, Ripple has been a big supporter of. I think it provides some of that clarity. I'm not up here trying to pretend that enforcement actions shouldn't be brought. There absolutely have been bad actors. There's no question. I'm not sure that, the irony of the Ripple case in terms of the reality is you have, I think now 75,000 XRP holders who want to sue the SEC. Now keep in mind the SEC's mission, one of their statements is to protect the investor community, to protect effectively consumers. So wait, how did they protect that community by filing a lawsuit and driving $15 billion of value out of that ecosystem?
Exactly.
Well, I want to kind of switch gears here a little bit. This part of this discussion is about enterprise crypto as well, and Ripple has a lot of institutional clients.
Did you hear that? Yeah, Ripple has a lot of institutional clients. It's not even up for discussion. She understands. She's done the due diligence. She gets it.
Can you talk about has the sort of lack of regulation in the U.S. has that affected your clients or your interactions with them, or maybe elaborate?
The reality, so Ripple definitely, since this lawsuit started, the last 2 years, we have grown gangbusters. We've signed, I think I've publicly said, hundreds of customers outside the United States. Yeah. So it has affected our business domestically, and the U.S. is still the largest economy in the world, and so I clearly care about that. But I also, the problem we're solving is a global, one of the primary things we focus on is this cross-border transactions, payments. And so, most people outside the United States don't really care that the SEC is suing us. I'll tell you a very quick, funny story. I'll keep it short. I was in the Middle East last fall, and we were meeting with customers. I have one of the Ripple team members who's based there. It's really early in the morning. My time zones are all screwed up. We're meeting the CEO of a payments company, and but the employee from Team Ripple says, "Well, why don't you give an update on what's going on at Ripple?" And I start talking about the SEC. And after the meeting, he very delicately says to me, "No one gives a shit." And his point was, if you're not in the United States, the governments in Abu Dhabi, governments in Switzerland, Singapore, UK, Japan, they provided the clarity how they view and categorize digital assets, and they don't care that the United States SEC has a viewpoint that is, pending in court.
Let alone counterintuitive to the rest of the world. Excellent fire from Brad. Here's a little minute clip here. It says a lack of regulatory clarity in the U.S. leads him to suggest new crypto entrepreneurs set up overseas, and it is driving Ripple's hiring decisions. Now, I'm not going to go into that because that's exactly what it does. Shout out to Crypto Law for that. But going on to back up the point that Brad's making here, Ripple launches a new Mumbai office to serve India's digital economy. Hello. Again, I ask you, as in the public comments back to the Treasury after the crypto executive order report came out, Ripple remarked as an example about the e-rupee in its comment. And I asked the question then, and I'm asking it again now. What does Ripple know about the e-rupee? Is it going to be launching on their private ledger as the Central Bank of Bhutan, Republic of Palau, and anyone else we're not aware of? There's more than a dozen we've heard from James Wallace. Ripple launches that new office in Mumbai is really exciting to me because I know that Central Bhutan has a lot of trade, you guessed it, with India. We'll keep watching it. And to this last little clip here, it's really what, this space needs to hear right now, even with us being attacked. I know I was recently blocked by Charles Hoskinson, but shout out to him. I disagree with him, but I've never been impolite. I've never been unprofessional or a lack of respect. I have a great respect for him and his brilliance and his innovation and what it could do and what I think it will do for this space, in fact. But the reality is we've been attacked. We've been, not attacked, but we've been addressed in a way to try to cancel us or dress us down. And that can't happen. So that's why I encourage everybody to remain polite, remain professional, so we don't create tribalism, but just really keep in mind that we're searching for the facts, the things that can keep us all together, and search for that common ground no matter where you come from in this space to work for a better tomorrow in the digital revolution here in the United States and certainly abroad. Take a listen right here from Brad.
The very, very last thing, which, if you've seen me speak publicly before, I will say the biggest thing holding crypto back is the tribalism in this industry. We are all on the same team. We don't have to kill each other to succeed. And I just don't understand why there's so much infighting so often. And I do think events like this help raise everybody, and that's a very positive thing. That's it.
It really is, no doubt about it. And to go on to what the case and what we're waiting for, here it is from Jim. Shout out to Jim Filan or Filan. We love you, buddy. You're awesome. This is Judge Torres over the SEC's objections to iRemit and TapJets, customers of Ripple who filed for the approval of application of the amicus briefs. And you know what? The judges granted it, ladies and gentlemen. That means they're going to be friends of the court, just as John Deaton is, and they're going to be able to show real examples about how they use XRP for money and not investment. The court has reviewed the request by iRemit and TapJets for leave to file amicus curiae briefs dated September 30th, 22, and the parties' letters dated October 4th, 22, October 5th, 22. Accordingly, the requests are granted. By October 14th, 2022, iRemit and TapJets shall file their briefs Amici are reminded that their briefs must comply with the requirements set forth in Section 3D of the court's individual practices in civil cases. How about that? The clerk of the court is directed to terminate the motion. So ordered. How about that? Another huge win for Ripple in the SEC case. I tell you. Things are happening every day, and we got more information to come. October is going to be a fun month for getting more information on summary judgment. That's where we are today. Not financial advice from me or anyone else. It's just my digital perspectives. I'll catch all of you on the next one.